What is a probate sale with court confirmation? So you're seeing a house for sale and it says court confirmation required. That seems strange. I mean, what's that about?
Yeah, what is it?
Well, we get into that next. Welcome back to the channel. I'm Brendan Mohr, Realtor in California and certified probate and trust specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed professional fiduciary in California. I'm also a registered and bonded legal document assistant in both California and Nevada. I'm a licensed real estate broker in California, as well as a real estate agent in Nevada.
Now, every day we help people save thousands of dollars and headaches with our one-of-a-kind probate administration service and probate real estate listing combo. So please reach out to us, whether you're in California or Nevada, about that service, because we can really save you a lot of money. See our contact information below, email us, text us, comment on the video, and remember to subscribe to our channel. Right now we have new information every week, and please do like this video as well. So Bill, this is often a very I'll just use the word complex, because a lot of people don't really understand what a probate sale with court confirmation, and that's kind of a loose term. We use a different term for that, but let's get into that. What is a probate sale with court confirmation?
Well, basically, it simply is a probate real estate sale that occurs most of the time, when an executor or administrator has only what's called limited authority. And when an executor or administrator only has limited authority, then he has to go to a court hearing to have the judge confirm the sale. That's the only way the real estate can actually get sold.
Yeah, so it's a much longer process, right? Yep. And we have a video on that as well. It's likely one of our most recent videos, actually. Yes. Now, this is quite a bit different than a normal sale. Now, most often the personal representative has been granted full authority, and that's more similar to a regular sale.
Yeah, definitely it is. There are some times, though, when even if you've been granted full authority, that you can be diverted back to a court confirmation sale, similar to when you have limited authority. For example, if you have full authority and if an heir objects to the sale, then that's going to bump you into the limited authority court confirmation type sale. Another thing that can happen is maybe there's another interested party in the probate that objects. I don't want to get that far into this with this video, but sometimes there are other interested parties in the estate other than the heirs. And if they object, that can force you back into a court confirmation type setting. It's really rare, but occasionally the court might, for some reason, on their own motion, say that they want this particular sale to go by court confirmation. Very, very rare that happens, but it is possible.
Now, perhaps we should go through some of the steps of a probate sale with court confirmation.
Sure.
So people have an understanding of what occurs and why it takes a lot longer. Now, the timeline of it, it could be 2, 3, 4, 5, 6 months, and it depends on the court and a number of other factors. Yeah. But the county in which the court is in is a main factor.
Yeah, every court is different in terms of their workload. For example, if you look at Los Angeles County versus, say, El Dorado County, nothing against El Dorado County, but they're a much smaller, more rural type county. They just don't have the volume that Los Angeles County has. So depending on how busy the court is, that can affect the length of time it takes to get a hearing date to confirm the sale of the real estate. And there's a number of other things that play into a court confirmation sale. I'll give you an example. If the decedent, the person who passed away, if it's been more than 1 year since the date they passed as to when the sale is going to take place, you have to go back to what's called the probate referee, who's a court-appointed appraiser, and you have to get another appraisal that's more current than the original one, which is done as of date of death. And that takes time, and it also has extra cost. So you've got to factor that into your timeline for the court confirmation sale. That's all got to be taken care of before that hearing date. Otherwise, it won't go through. Another thing is you could get the petition to confirm the sale filed with the court, obtain the hearing date, get all the proper notices out, and if you don't get that done within the proper time frame, there's a certain time frame that you have to do that. And if you miss that window, that's it. It's not going to go through. The court's going to bump you out to another hearing date further out to give you time to get done what you didn't get done the first time.
So you really need to be working with someone who's very professional, has done this
Absolutely.
before. And
Yeah.
in my experience,
Yeah.
on the real estate side of things, you need to be working with an agent who has done this before.
Yes.
Because it is dramatically different
Yep.
than a regular real estate sale. So it's dramatically different than a probate sale that does not require court confirmation,
Right.
which is typically, most of the time, is one where they have full authority.
Yeah.
You want to talk about maybe we're to this point or not, but maybe the process of actually the sales process.
Oh, sure.
So I'm
Sure.
sure that a lot of our viewers, they've either come across or have to sell a house where court confirmation is required, and typically in a limited authority situation.
Yeah. Yeah. Well, when you actually get to the court hearing, if you've got everything done that you're supposed to get done before the hearing itself, a lot of people don't realize this, but the judge is actually going to open it up to potential overbidders. Because part of what you have to get done before you get to the hearing is it's required that you publish what's called a notice of sale in a newspaper that's approved by the court. That's a general circulation in the area where the house is located. Now, what that does is it basically advertises to the world, hey, there's going to be a court sale of this house at this hearing date, this particular time and place. And there's people out there who, on occasion, they'll come to court and they'll bid. So you have to be ready for that. And that's where, again, it's very important that you have a realtor that knows probate, because a lot of realtors that don't know that, they don't get everybody to the hearing that's supposed to be there. You got to have your buyer there. You got to have the seller there. You got to have both agents there. If there's an attorney involved, it's a good idea that the attorney be there. But the realtor that is working for the seller in the estate, he needs to know all these things. And he needs to make sure that all that gets done and those people show up at the hearing. Because if they don't, and you get an overbidder there, you got problems. Things are going to be delayed for sure. For sure. So there's a lot that needs to be done, and a lot that realtor needs to know and do.
Now, we have a whole video on the court confirmation overbid process. I think it's called "What is a Probate Sale Overbid Process?" or "What is the Probate Sale Overbid Process?" And it's important to know that when they do open up for bidding, essentially a bidder is bidding on the actual contract itself. So, say somebody. The personal representative accepted a cash offer at $500,000. Well, and there's no contingencies, so the bidder is bidding on the exact terms of that contract. But first bid isn't 500,000. It's a little bit of a not really complicated, but it's
a little bit of a calculation.
Yeah, the little bit of the calculation for the overbid method.
But
about 5% plus $500 over the contract price. So whatever it is, 500. If a $500,000 offer was accepted, 5%, an additional 5% plus $500 is going to be that first bid, and then usually they open it up for $1,000 bids after.
Yeah,
after
the judge will set an increment. It might be $500, might be $1,000, might be $2,000. It just depends on the value of the property that you're dealing with. But I will say also, and I know we've discussed this in the past, Brennan. Believe it or not, it's not that often that bidders show up. I mean, it does happen, but not that often. And the reason is if the property, again, you've got a good realtor working for you that knows probate. If the property has been properly advertised and marketed, then you should be getting a fair market price going into the court. So if someone's going to come in at 5% over a fair market price, they better have a good reason to do that. Otherwise, they're overpaying for the property.
Yeah, right. Because as long as the property was appropriately marketed, say 500,000, you're looking at 5% higher, that's somewhere around $25,000 more. Why didn't somebody offer $25,000 more a few months ago? unless it's maybe a hot market. We've even seen ones where it was a hot market and still no bidders showed up. Now, it is always a possibility. And if a buyer wants to, they can join in the overbidding.
Correct.
They can outbid an overbidder.
Yeah. Yeah.
And
the original buyer on the original contract. That's why it's very important that the buyers show up. As Brendan said, he can, if there is another bidder that overbids, then the original buyer is allowed to bid higher if he or she wants to.
yeah, plus at the hearing, the judge often has questions.
Mhm.
Sometimes they ask, "Is the buyer here?" And they might have a specific question
Yeah.
for them. Same with the seller. Same with even the agents involved. So it's
Absolutely.
very important to be at that hearing. And thankfully, most of the hearings that I've been to recently, they've been over Zoom, so you didn't actually have to go into the court. But as far as I know, most of them are allowing inside the court hearings. They weren't during the COVID times, and that's when they really converted a lot of
Yeah.
those to Zoom.
Yeah. But most courts now are back open where you can actually go to the hearing in person.
But if you are seeing a probate sale out there that says court confirmation is required, or you're about to be involved in one on the selling side, I mean, really the process is it's marketed. You're probably marketing it for at least a certain number of days. I like to give it at least a decent market showing and set an offer due date. That way, we are sure we are getting the best offer and we don't have complications later on. And then well, a big part when it gets to the court confirmation hearing is there cannot be any contingencies once that hearing um, is commencing, and we'll get into kind of what that means maybe towards the end of this. But if there are contingencies, and such as an inspection contingency or appraisal contingency, a loan contingency, if it's finance one, you need to get moving on all that very quickly. And a lot of times, a buyer is a little bit scared because you may only have 10 days to do all these things. 10 to 21 days is maybe the longest I ever see, or 17 days, somewhere around there. um, and you need to remove those contingencies, but your court hearing may not be for 3 months. So if you're getting a financed if you're doing a finance purchase, you need to be really sure and have everything really really set.
Yeah.
um,
Rate locks on loans can be tricky with a court confirmation sale, especially if it's going to go for 2 months, 3 months, or that can be really tricky for a buyer.
and because the seller, on the seller side, there's the publications that they have to do,
Mhm.
filing for
Filing fees.
yeah, filing fees and all that. If a buyer um, cancels the purchase after these fees have been paid by the seller or the seller's estate,
Yep.
well, they're out all that money. So to protect themselves, often what you'll see is those publications, those filings to get the court hearing won't actually take place until you have released all those
Right.
contingencies. Otherwise, the state could be losing over $1,000,
Yeah.
maybe
Yeah.
more.
The estate runs that risk.
Plus, if the contract is changed at all, sometimes you go
Yeah.
into and it's sometimes a kind of a myth that you can't ask for credits towards closing costs in probate, but you often can.
Sure.
It's more common that an estate won't do repairs, but credits to closing costs maybe because you found
Yeah.
something in your inspections. But say you ask for a $10,000 closing cost credit, and the estate says, "Okay, yeah, we'll give you that credit." Well, if you've already sent in that petition for the hearing and the publications, now you have to do it all over again.
Yeah.
So you need to have those in early.
Yeah. And that again is another reason why you want a real estate agent that is extremely well versed in probate, because one that is going to know these things, and he's going to be able to advise his seller, look, let's get the contingencies released, let's get everything that needs to be done. If there's any credits that are going to be given, we need to make the buyer aware that, look, once we agree to this, that's it, there's no changes, because otherwise the estate, just like you said, Brendan, is going to be out money, because they're going to have to repeat their filing fee and repeat their publication fee. So it's really really critical that you have a realtor that knows probate.
And often the earnest money deposit, you'll see they're maybe requiring a larger deposit. It's not typically, well, often I do see it required by either the agent, or perhaps it's on the advisement of the probate professional, the attorney or service handling the probate. But there's actually nothing in the probate code that says it has to be higher. It might be a local court rule, maybe
Possibly, yeah,
sometimes,
possibly.
but usually the earnest money deposit is higher because they want to make sure that that buyer commits to that contract, because the time period is so long.
Yeah,
The seller wants, the seller's estate wants to recoup some of those losses if they do have to go on the
right.
market.
Yeah, exactly. Yeah, and also just what you said, having a buyer that does put in a higher EMD, a deposit, um, shows that he's committed, and that helps the estate and the seller because they're putting out money, additional money to get this going, and they want to be sure that they've got a buyer that's committed to the sale.
So yeah, once you get to that hearing, judge opens up the for the bidding. Say nobody bids on it. Now, one thing that's going to happen there, let's just say you haven't removed the contingencies in writing, and now the judge has just confirmed that sale. Bill, do they still have contingencies?
Nope. Nope. And that's a really good point.
Yep.
The judge, by signing that order confirming the sale, whether or not that buyer had released contingencies, he just released contingencies because the judge just ordered it.
Gavel, gavel.
That's it. That's it. Yep.
Yeah, he says you're buying it.
That's right.
Oh, but I just found termites.
Too bad.
Yep.
Once that judge signs the order, the buyer must follow through and buy the property.
If you want to back out of it, you're going to be back in court. You're probably going to lose your deposit at the very least,
Yeah.
and maybe worse.
Maybe more. Yeah. The probate court and judge has the ability to order damages. They do.
So you got to be prepared.
Yeah.
And if you don't play around with those contingencies, remove them. Do your due diligence. Remove your contingencies. And if you're advising, maybe you're somebody advising a real estate client on it, make sure they know that, because a lot of times they're not advised that. And a lot of times they think that the time periods in a contract are start at the court confirmation hearing, which is, I'm surprised I didn't actually bring this up. It's a common misconception, and I like to educate agents on this a lot. That a lot of times there's like an escrow period of whatever it is, some odd number of days, but say a contingency period, an inspection contingency period of 10 days. That starts at the time of acceptance
Correct.
of the offer. It does not start from the date of the court confirmation. You don't have contingencies once it's been confirmed.
Yeah.
It starts at acceptance. And a lot of times, I'll have agents and their buyers think that their time periods start at the time of the court confirmation.
Yeah.
And it's just not the case.
Nope.
So yeah, what happens then? Gavel, gavel. I've ordered you to buy this house.
That's right. Yeah. The judge orders you to buy the buyer to buy the house. He signs what's called the order confirming the sale of real property. It's not over there. That's not the complete end of it. Now, and again, you want a realtor that knows this. Now what has to happen is you have to get a court certified copy of that order that the judge signed at the confirmation hearing. And that court certified copy has to get to title. Title company cannot close escrow without that certified copy. And a lot of people forget about that. Even probate attorneys, I don't know that they really forget about it, but they just don't always follow up as quickly as they should in order to get escrow closed. Really important. You get that certified order over to title.
Yeah, it is a possibility to get it the same day if you're at the courthouse. A lot of times you have to order it, make an appointment to get it, or have it mailed to you. And a real situation, because Bill has probated thousands of estates. Right? Am I right? Thousands. Yeah. I don't want to misrepresent that. Bill knows this back and forth. So we were in a situation where we were not, where Bill was just working as a realtor with he and I, and there was an attorney involved actually probating the estate. And it was a court confirmation hearing. And it was a long one. It was like 5 months long. The buyer really wanted to close. There was it was a finance sale. There was a rate lock involved. If you know anything about interest rates and rate locks, it costs a lot of money. It can cost thousands of dollars to extend rate locks. So all this was at danger. We needed that court certified copy of the order, and Bill ordered it that day. from the court. And at that time, you could not go in because this was during COVID
Right.
times. You could not go in and pick it up, so we had to wait for it to be mailed. Well, took about 2 weeks to
Yeah,
get it.
roughly.
Brought it in the title company, and we closed that day. About 3 weeks after that, so we're talking 5 weeks
Yeah.
after that hearing, Bill gets a call from the, or maybe it was an email from the attorney's office, and what'd they say?
They said, "Oh, we've got a certified copy of that order for you," and we kind of said, "Well, thank you very much, but we got one earlier, and we've closed escrow." Yeah.
So just make sure you're working with an agent who knows probate back and forth, because in that particular case, if you weren't, it could have blown the whole thing right there.
Absolutely.
Maybe the buyer in that case would have had a case when they go in front of the judge and they say they can't buy the house. Hey, it's the attorney's fault. They didn't get the appropriate document in time.
And that just, I mean, I hate to talk like this, but when those types of things happen, it just kind of opens the door for legal problems and lawsuits in there. And, it just does. So it's always better to have a really good probate real estate realtor on your side that gets things done as soon as possible. It just saves a lot of headaches, a lot of hassles, and potentially a lot of money.
But we have a lot of videos on these subjects about the overbid process, full authority versus limited authority. We have another one just about full authority. And that's I don't know that there's much more to say on this.
I think we've said a lot.
Yeah, but what you really want to do is you want to expand your knowledge on this subject. What we have for you is our video, full authority versus limited authority. It's going to pop up right around Bill's head over here, right at the end of this video. Please click on that to watch more, and it's linked next.